Yeah, that's I think it's the way
I won't be here for this. I'll take one up to really?
well, I heard it.
Yeah. Or they just keep it for 3 or 4 days. As long as you don't get selected. Right. You got a bunch left still? Yeah. Yeah, I went to Palm Springs. 10 days. Yeah. Yeah.
Do you?
I got to put the door in the kitchen. I got a window. I want to hear the door. No, that's the last thing to finish off the kitchen. I got to get a bricklayer. One of the bricklayer. I'm with it. You don't design your own thing. You just let it go, right? Got all these Indian, all these beans in your head. It's time to never ends.
Good morning.
Yes, the clients.
My name is Keith Bannon. I'm the managing partner of Glaholt LLP. I'd like to welcome all of you. On behalf of the firm, I'd like to welcome all of you to our program today, both those in person and those who will be viewing online. So what will be the first program? The first part of what will be a 3-part program titled the Glaholt Leadership Series. The idea behind this program was developed by our partners, Andrea Lee, Dr. Glaholt, to offer an educational program to those that we work with. In developing the series, they were able to draw an insight not only within our firm, but also provide us with the added benefit of hearing from several industry leaders that we have the privilege of working with. And this is important because, as we all know, there's going to be a lot of change very soon in the construction law in Ontario. And we want to provide insight into how best to navigate this change. Of course, today's example, we have the added advantage of drawing upon experiences in another jurisdiction, which will be a very valuable tool in learning how to navigate this change. We also want to provide insight on how to best develop construction claims and, more importantly, resolve them. And again, we will be hearing from people within our firm and experts from outside that we work with. Ultimately, we hope to find these programs helpful. And without delay, I'll turn it over to the moderator, Jana Flani, to properly introduce our panel.
Thanks very much, Keith. Welcome to our audience in person. Welcome also to our audience that's joining us by webcast. As Keith said, my name is Jane Afwani. I'm a lawyer at Glaholt LLP. I'm pleased today to welcome you to this panel on statutory adjudication in Ontario. This is the first installment of the Glaholt LLP Leadership Series, as Keith said. We're privileged today to be joined by a panel of esteemed speakers, each of whom brings their own unique perspectives to the implementation of adjudication in Ontario. Fleur Kitchingman, immediately to my left, is the Senior Vice President, Legal and Corporate Secretary of Carillion Canada, where she has worked since 2007. Fleur has over 20 years of experience in the construction and infrastructure industry in both an in-house and private practice role. With her early career spent working in construction departments of national and multinational firms in the UK, she conducted some of the very first construction adjudications in the UK after its introduction in 1996. Chris Larkin, on the far left, my far left at the other end of the table, is a Senior Managing Director at FTI Consulting in the Forensic and Litigation Consulting practice. Chris leads FTI's Construction Solutions Group in Canada. Chris is a chartered civil engineer with more than 28 years experience in the construction industry, including 22 years specializing in construction contracts and dispute resolution. Chris has acted in both a claims management role and as an expert witness in mediated and adjudicated disputes in the United Kingdom, assisting clients with the assessment, settlement, and prosecution of a claim through the adjudication process. And of course, Chris plays a similar role in Canada as an expert witness. Lastly, Duncan Glaholt joins us today. Duncan is a leading practitioner in the field of construction liens and trusts and construction litigation in general. Duncan has been a champion of adjudication in Canada for many years. He's the co-author of the annually published Annotated Construction Lien Act and has authored numerous articles on the implementation of statutory adjudication in Ontario. Duncan has nearly 40 years of experience as an advocate since being called to the Ontario Bar, and has sat as both an arbitrator, mediator, and dispute review board chair in the resolution of many major construction disputes. Welcome today to our panel, and thank you all for joining us. I'd like to start by grounding us a little bit in the topic of adjudication. And Duncan, I was wondering if you could give us a little bit of background. Tell us a little bit about, first of all, what is adjudication? Because not everybody in the audience may be familiar with it. It will have a meaning in Ontario. It has a meaning in the UK. Could you tell us a little bit of brief background to the proposed reforms of the Construction Lien Act? What is statutory adjudication, and how are the reforms of the Lien Act incorporated?
That's so a multiple part question.
That's right.
Thank you, Jay. So I would like to join in Jay and Jay's comments and welcome all our clients and friends here and the people joined by WebEx. This is a very important development in Ontario law. I believe it will prove to be a very important development in the Canadian law of dispute resolution. The other provinces' attorneys general are watching the developments here in Ontario very, very closely. So we're present for something that is new to Canada. Fleur and Chris, it's not at all new to them. The UK model of adjudication, which grew out of the private industry, grew out of the practices of Robert McAlpine back in the 60s and 70s, institutionalized by legislation there in the 90s. Fleur and Chris have lived it. So if you see me head down, scratching away at my notepad, I'll be taking notes from both of them because they've lived their model. Our model is different. We have not adopted the full UK model of adjudication. There are some important distinctions which, Jay, we have the time. I'm going to just sort of enumerate a few of them and try to answer your multiple part question. I would like to orient the audience first by saying that we talk about adjudication as a dispute resolution technique. I think that's accurate, but I don't think it's completely accurate. I think that in the room in Ontario, we should see it also as a dispute avoidance technique, because the information I have from my friends in the UK is that you might see more smaller disputes, but you tend to see fewer larger disputes. We'll see. What is it? What is adjudication? I think just the report that you've all read, the Reynolds-Vogel report called Striking the Balance, which is a very important title actually, said that it is a swift and flexible mechanism of dispute resolution. And I certainly agree with that. I think it's actually more. It is designed intentionally to provide parties with a determination in a very short time period, a reasoned, written determination on a summary basis, usually within one payment period or at most two. As we'll hear, I think, from Fleur and Chris later, sometimes those periods are extended, and I'll be very interested in learning that. It gives the adjudicator, and we'll talk more about that person this morning and how they're appointed and how they're qualified and who they are, and what happens in the UK and what might happen here. We'll talk about that. But they will be qualified people. They will be people that are qualified to look at these disputes. They will have something that is the other drum that I've been pounding since about 2004 or earlier, which is they will have inquisitorial jurisdiction. So the adjudicator will not be a passive participant in the process. Conceptually, the adjudicator will be a person that can ask questions, examine documents, demand documents, can really work to get to the heart of a dispute, and then make a determination. That is not a small job. Any of you that have sat as arbitrators or dispute board participants will understand how difficult a job that is, and it must be done in an extremely short period of time. In our jurisdiction, 30 days from the receipt of the adjudication papers by the adjudicator. And if you think of some of the disputes that you and the audience have been involved in, you can imagine how difficult that will be, how difficult it will be, and Fleur and Chris will speak to this, just to assemble those documents, to respond to it. And if you're the adjudicator, how difficult it will be to respond to it. But this is what is done. If the adjudicator fails to do his or her job, they lose jurisdiction and may lose their fee. The decision of the adjudicator is not a permanent decision of the dispute. This is a vital takeaway for everybody watching and present here. It is an interim binding decision. Other jurisdictions deal with it in other ways, but in our jurisdiction, the determination by the adjudicator will stay binding and enforceable unless and until it is overturned by party agreement. So Fleur and Chris could agree to dispense with it, and that happens. Or it's resolved by an arbitrator or resolved in litigation. And at the risk of being a little long-winded, that brings me to the next feature of adjudication under Bill 142. So I've told you that it's a dispute resolution mechanism that you should think of as also a dispute avoidance mechanism. You need to also think that it lives within a construction lien statute. So in the UK, it's a part of the Housing and Regeneration Grants Act. It's part of a sort of an omnibus reform bill that came through with many, many parts to it. Here in Ontario, we're doing it differently. Here in Ontario, it is a piece of reformed lien legislation. So it lives and exists within a lien statute. It also lives and exists with new prompt payment provisions. And that goes to the heart of what adjudication has been in the UK. And Chris and Fleur, I'll turn to you shortly to hear if it's worked, but the idea is to get the money moving, right? Get the money moving. Let's not have gridlock. Let's not have people in standoffs pointing weapons at each other. Let's get the money moving. And we'll be interested to hear how effective that's been in the UK. So it lives within a lien regime. It's twinned with a prompt payment regime. It's all about cash flow efficiency and not having people withdraw performance unless they've had a dispute adjudicated. It removes gridlock. It enables payment. It gives people the confidence, and many of you in the audience will have been in the position of wondering, what do I do now? Should I pay? Should I not pay? Should I walk off the job? Can I down tools because of not payment? What will my bonding company do if I down tools? What will the owner do to my bonding company and me if I down tools? The statute in its few provisions, section 13, and subsections, 24 subsections, it tries to deal with these issues because the bonding company will now, it's possible to join the bonding company in the adjudication and have consecutive adjudications. Jay, I'm so sorry, I think I'm straying away from your point.
This is very useful background, Duncan. Thank you very much. You may have anticipated some of the ground that we're going to cover later, which is also good. Let me ask you just a couple more quick introductory questions before we turn to Chris and Fleur's experience in the UK. Could you tell the room a little bit, and those watching on the web, what disputes adjudication is going to apply to and what it's not going to apply to? And could you say a couple of words about the timelines that are going to apply?
Sure. This is, I rehearsed, and good question, because it is very different here in Ontario than it is in the UK, and Flora and Chris are much better able to speak to the UK model. But here we have what is called targeted adjudication. The recommendations of the Reynolds-Vogel paper were not to adopt the UK model wholesale, but to make it targeted. So for those of you that are interested in the statute, section 13 sub 5 has a list of those things that can be adjudicated. And they're all, as I read them to you, and summarize them for you, they're all payment related. So the first one is valuation, which is a fascinating word, valuation of services or materials under a contract. Disputes over, I would say, how much, how many, what is it worth, how much fill, how little fill, what is the steel worth, those kind of disputes. Payment is the next one. Payment including change orders and contemplated change orders. And as I go through my list, you're seeing the arms go wider to embrace more disputes. So payment including change orders and contemplated change orders. Next, notices of non-payment. This new thing that lives within the prompt payment regime. If you're going to short pay someone, you have to tell them that. You have to give them the notice of non-payment. So obviously that's swept in. The next one is amounts retained by way of set-off. All of us have seen or participated in that game. Yes, I know I owe you $500,000 in this program, but we have many set-offs. Set-offs for what we have been here on other projects, debts you owe us. Those set-offs are included in the statutory jurisdiction. And that's both with respect to lien and trust claims. Non-payment of holdback. Non-payment of holdback. Non-payment of holdback, which is curious because the authority of the adjudicator ceases and the ability to bring an adjudication ceases in our jurisdiction at the completion of the project. And Chris and Fleur will talk about what it might be like in the UK. And then the last one is my favorite one. Anything that is added by regulation. So we don't have those regulations. They were supposed to be out now. They aren't. And this is very important for all of you. The Bill 142 that we're talking about will not be the Bill 142 that you see when it's eventually enacted, let alone in the regulations. So the elastic definition, Jay, of disputes that can be adjudicated is meant to be added to by regulation. So if this experiment proves a success here as it did in the UK, I think we'll see it grow. So timelines and transition. So first of all, transition, and I'm using way too much time. I apologize to my co-presenters here. This is what happens when you mic me up. So timelines, transition. The Minister Nack, the Attorney General, has been very clear about this in Hansard. This has troubled the industry. Oh my God, is this just going to drop on us all of a sudden on January 1, 2018 and disrupt everything we're doing? The answer is no. If you look at Hansard, Minister Nackby at the second reading is very clear the transition will be gradual. It will be perhaps, we think, staged. So the amendments to the nuts and bolts of the Lien Act may come in first, and the prompt payment and adjudication pieces might be proclaimed later. But no one's going to be taken by surprise. No one in this room, no one on the web audience will be taken by surprise. There's plenty of notice. Regulations will be out. You'll know what's coming, and contracts are entered into after the proclamation date will be effective, not contracts entered into before. For those of you in businesses that work by RFP, if the request for proposals is on the street, chances are it will not be before the proclamation date. Chances are it won't be effective. And Jay, just to wrap up the timelines, very similar to the UK, slightly different, but very, very similar. It all begins with a notice of adjudication. So advantage to the referring party, because the referring party can squirrel up and get ready and serve a notice of adjudication. So the notice of adjudication goes out. You have 4 days to agree to your adjudicator, or to refer to a new creature called an adjudicator nominating authority, which the government's going to set up. The adjudicator nominating authority, and the acronym is ANA, you can think of it, it probably will be called that. The ANA has 7 days to provide you with an adjudicator. There will be lists, there will be training, there will be qualifications. We don't know what that will look like. That's all going to be part of the regulations. We don't know if it will be what they call a cab rank. So all the adjudicators in the province are in a list of some kind, and they pop up sort of one after the other and then go to the bottom of the list. We don't know if it'll be random, names drawn out of a hat. We know the parties can free, but if you go to the nominating authority, that's all to be decided. So you're kind of 11 days into the process then. Then the referring party has 5 days from the appointment of the adjudicator to get the documents together. Now the referring party has the advantage of time and probably has that body of documents together. The documents then go to the hands of the adjudicator, and that's when the adjudicator seizes the matter and begins to exercise procedural and inquisitorial jurisdiction. Will convene either a conference call or a meeting of the parties and will determine the process to be followed thereafter. So what limits are there for that? Wouldn't that just go on forever? Well, the adjudicator, once the adjudicator gets the documents, has 30 days to get the job done. So the adjudicator has 30 days or loses his or her jurisdiction. So 30 days from receipt of documents to get the job done and write a reasoned determination. That can be extended. So the adjudicator can ask for up to 14 more days, but not more. Again, the parties have to agree. The parties, on the other hand, can agree to any extension between the two of them, provided that the adjudicator agrees. So it's, if you've been doing the math, it's a process that could be as short as 30 days. It could be as long as 40, what did I calculate, 55 days if everything was going according to the statute. So it's going to be a dispute arising in one pay period that will be resolved in the second pay period.
Thank you very much, Duncan. I think that was very helpful background just to orient everybody into the reforms that are coming. I'd like to turn to some of the experiences that have been had in the UK. Fleur and Chris, I'm wondering if you can tell us how the industry accommodated these extremely tight timelines for adjudication in the UK. Fleur, why don't we start with you?
So when adjudication started in the UK, I was a young lawyer in private practice in a law firm. As you've heard from Duncan talking about the process, it's really kind of like trying to do a mini court, doing a mini court process. So you've got your referral notice, which is your referral to adjudication, which is similar to kind of putting a statement of claim together, I'd say. You know, you do a response to that in, say, 7 days, which is your response to the referral notice. So it really is trying to condense that whole process into a very, very slim time period. I found in private practice it was very, very difficult to work on anything apart from one adjudication. So all the other matters that I had at that time just kind of went out the window because all you could focus on in that one period of time as a lawyer was doing that one adjudication. I think it was also very difficult for clients. I've seen it on the other side as well, because working in Carillion, we always had adjudications in the UK. That's very difficult as well because it's very demanding of the client's time. You're trying to get a whole process, kind of a whole mini kind of court process together in a very, very short space of time. It's not just about putting your claim documents together or your defence documents together. There's a whole raft of queries that kind of happen in between as well that kind of need responding to. So when I first started out in private practice, we had the fax machine. But the fax machine was kind of constantly going and things were constantly coming in from the adjudicator, constantly going back out again. It was kind of really kind of dealing with it all in very, very real time. As Duncan was saying, the referring parties really got the advantage here because they've got a lot of time to kind of put their claim together and put their documents together. As a responding party, you're very much kind of on the back foot there. So there's that kind of whole timing issue as to when the adjudication starts and just making sure you've got people available to deal with this kind of very, very intense time period.
Chris, I wonder if we can get your comments on how the industry adapted to these tight timelines.
Okay, well, like Flora, I was working in the UK when the Construction Act was introduced and adjudication was introduced. I was working for an expert witness and claims consultant, so I saw it from a slightly different aspect. What we found is that certainly initially, many of the parties, they just weren't prepared for adjudication, particularly the short timescales. They'd been more used to arbitration and litigation, where timescales are much longer. And so immediately, where something was referred to adjudication, had a very short time to react. And a lot of the companies just weren't prepared for that. And I think it took a bit of time for them to catch up and to take this into account. But I mean, obviously it's been a number of years now since adjudication has been enforced in the UK. But what we have seen how the parties accommodate the timescales. Parties, we think it's improved contract administration. So we find contractors, subcontractors, their record keeping, how they organise their record has improved. So when they have an adjudication, if they want to refer the adjudication themselves, or if they're the responding party, they're reacting to a subcontractor's adjudication, they're much better prepared. And what we also found as well is that because within the Construction Act in the UK, there's introduced new payment provisions which require the submission of payment application with proper supporting information. We found that those payment applications are much better as well, so they will be more easily understood. So that sort of ties in with the better contract administration. I think the other way they're able to accommodate timescales are closer relationships with law firms in particular. So when an adjudication did occur, they could very quickly call on a trusted law firm to come in and assist them within a short timescale.
Thanks very much, Chris. That's very helpful. I'd like to explore a little bit the differences between adjudication and the common dispute resolution provisions that we're familiar with in Ontario. Now, Fleur, you've had experience as a lawyer dealing with disputes on construction projects, both under schemes of statutory adjudication in the UK and here in Ontario, where adjudication has not existed to date. Chris, of course, your perspective is as an expert who's assisted clients in both systems. And Duncan, you've had a long-standing interest in adopting statutory adjudication in Ontario. I'm wondering if you could each tell me what you see as the key differences between the scheme of statutory adjudication and dealing with the dispute as we're used to in Ontario under a court-based system or an arbitration through the dispute resolution provisions of a contract. Fleur, perhaps we could start with you.
Yeah, so adjudication is much quicker and it's much more immediate than going through courts. But then it's also a lot more of a rough and ready process, and I found it to be much more of a gamble because there's not a lot of time for an adjudicator to properly get to grips with the dispute and consider all the documents. So, for instance, in litigation and arbitration, there's a long period of time for a judge or an arbitrator to actually consider all the documents. For instance, in litigation, you go through examinations of discovery. So there's a long period of time for the person who's deciding what's going to happen with the dispute to actually understand those documents. But also a long time, I think, for both of the parties to actually understand their cases a lot better. So I think that adjudication is a lot more rough and ready. And what we actually found in the UK was that it actually led to parties trying to enter into settlement discussions a lot more quickly, because they had that threat of adjudication. So the idea being that if you couldn't get a settlement with the other party could cross off to adjudication and get a very rough and ready decision that wouldn't necessarily be in the interest of either party. So there's a real kind of sense of you lose control when you hand it over to adjudication. So I think that in itself led to construction disputes being more quickly resolved by settlement. Because it was just seen as too much of a gamble for either party to kind of enter it to go to adjudication. But having said that, it was there as a result if you could get to settlement.
Chris, what do you see as the key differences between adjudication and our current dispute resolution regime in Ontario?
Well, I'll really speak from an expert's perspective. So in my experience, what I found was that for the referring parties who refer the dispute to adjudication, they would appoint an expert very early. So the expert would have the luxury of more time to investigate the facts, look at all the documents and the issues. And very often, the responding party, they wouldn't have an expert appointed. So when the dispute is referred to adjudication, the responding party's expert is immediately put at a disadvantage because he just won't have the time to properly examine all the facts. And the other key difference is really from an expert's perspective as well is that most of the adjudications in the UK were documents only, so there wasn't a hearing. So there wouldn't be an opportunity to test the expert's evidence by cross-examination or testimony. And also, there wasn't a simultaneous exchange of expert reports like you would have in arbitration or litigation. And there was generally just the submission of the assertive report. You wouldn't have rebuttal reports or responding reports. So it's not only the timescale, but also the process for the expert is very much different. But again, I'm coming back to something that Fleur said earlier, it can be a bit rough and ready. If the expert hasn't got time to properly investigate all of the facts, then you have to sort of question the value of their opinion.
Thanks, Chris. I decided to change things up a little bit so you don't have to look behind you when I'm to look at me. Duncan, could you tell me a little bit from your perspective, what are the key differences?
It's a little bit like a game show host.
That's right.
So look, I have my perspective, which is from the sort of mediation and arbitration point of view. Where you said something that really resonated with me you said it becomes a bit of a gamble. And those of you that have mediated with me know that's a favorite line of mine. I think all litigation and all arbitration is a gamble. It's a casino. It's a bet. And what you do when you settle a case is you decide to value and price that bet. So yes, it is a gamble, but in my observation, so is all dispute resolution. So distinctions. First of all, the most unique distinction is that this is an interim binding result. So what that means is that courts will respect it. It's not susceptible to appeal as such. We'll come back, Jay, we come to that later. It's not susceptible to appeal, so it's not like the final binding decision of an arbitrator or a court. It's an interim binding, rough and ready, Bruce said and Chris said, rough and ready kind of determination. Something very, very different. And therefore, stimulates the movement of cash through the system, which is one of its goals. Second point, I think both Phil and Chris touch on, it's not overtly concerned with settlement. So just like it's not litigation and arbitration, it's also not mediation because its focus is not settlement. Although I had a very interesting conversation recently in May with a man, I think Brooke just made know, Matt Malloy, his name is, he's a quantity surveyor in London, does a lot. In fact, his exclusive job is adjudication. He said one of the unexpected outcomes of rough and ready adjudication is an upswing in mediation, because large parties in complex disputes may not be comfortable with the result obtained in the adjudication, so they will get together afterwards and sometimes with a neutral, a third party facilitator, try and resolve the issues that the adjudicator didn't perhaps properly come to grips with. It's also, I think you hear this from Fleur, very much a client-driven process. So instead of we lawyers converting everything into a rights-based argument and bringing our rules of civil procedure out and sort of speaking in foreign tongues, it's very much a client-driven process. The clients do a lot of the advocacy, if not all of it. They interact with the parties, very democratic process, unlike anything, I think, else. I'm sorry, Jay, I keep going, but it's inquisitorial as well. The jurisdiction to be inquisitorial exists already in the Ontario Construction Lien Act. On reference to a master, the jurisdiction sections clothe master with inquisitorial jurisdiction. And I've talked to them all for many years, and they're all shy of exercising that jurisdiction. They know it's there, but they don't want to be overturned, so it doesn't get exercised. No one's overturning an adjudicator, so they can exercise this wonderful inquisitorial jurisdiction like a civil law magistrate might. And then Chris and Fleur both said this, it's almost always documents only. So to civil law lawyers, it's much more familiar than it would be to common law lawyers. We're big believers in the common law system and oaths and cross-examinations. It's much more a documents only process.
Thank you. Fleur and Chris, in your experience, did statutory adjudication limit large end-of-project claims by dealing with issues as they arose on the project? Fleur, why don't we start with you?
Yeah, I mean, in terms of adjudication, it was very kind of fast-paced. It's a bit quick and dirty, but it got the parties an answer, and most of the time they actually did live with that answer. I think it really kind of forces parties to be quite realistic about their claims, and makes them think about what's properly claimable at a much earlier stage. And 9 times out of 10, people would actually live with the result. You've got somebody that can give you that sense check to the claim.
Chris, was that your experience as well?
Yeah, absolutely. I've heard that. So what I very often find is that on some of the large construction projects, that parties might have multiple disputes that they would be resolved. So they would be quite selective in what they refer to adjudication. So often they refer to the dispute they feel most strongly on, or perhaps the one that's got the most value to it, and they get a decision on that. And what I found was that very often that would lead parties to negotiate the remaining disputes. So much earlier involvement with the dispute resolution process, and yes, certainly limiting or reducing the number of large end-of-project claims.
Systemic change never comes without risks, and I'm wondering if I could ask you.
Point, right?
Oh, I'm sorry.
It will be a small one.
Please go ahead.
Just to add to what Fleur and Chris have said, I had the honor of meeting with Justice Colson of the Technology and Construction Court. And this goes to the kitchen sink end of contract claims. He said that the business of the Technology and Construction Court, which is their UK's construction court, dropped off. He used the word precipitously. So the large claims didn't survive. They went from 1,350 annual large claims to 250 as a result of the advent. They went down from 12 judges to 7 judges and sinking. And the people I talked to called it what they called the kitchen sink. Does that mean about the kitchen sink adjudication? So at the end of the contract, and I think we're going to see that because of our jurisdiction to adjudicate holdback disputes, the kitchen sink where everything gets thrown in. You won't pay me my holdback because you have set-offs and this and that. I think we're going to see what in the UK I think they call kitchen sink adjudication.
Well, that would be a blessing, perhaps, given the limitations of the lien masters in Toronto, if we can get the number of disputes down. So I was going to ask about the risks of adjudication, because as I was saying, systemic change never comes without some risks. And I was wondering, from your perspectives, what are the major risks of adjudication compared to traditional litigation and arbitration? And so why don't we start with you?
So the risk is firstly in terms of the adjudicator that you get and the quality of the adjudicator that you get. They may be good, they may not be good. So that's one of the risks. And then the other risk, I suppose, to identify is even if the adjudicator is very good, he's only got such a limited time to get his arms around the dispute, to properly understand the dispute. So that's another risk in terms of just the time scales of actually getting to a resolution, and whether they've got enough time to properly understand it and reach the right decision.
Chris, what do you see as the major risks?
I mean, building on what Flora said, and it's been said before, it's very rough and ready, and that's really driven by the timescale. So it's not only the limited time for the adjudicator to consider all the issues, but for the parties to prepare their arguments and for the experts, if the right experts are appointed to consider all the facts. And you can end up with a situation, and certainly some adjudications I was involved with in the UK, one in particular where the adjudicator, it was a quantum issue, it was a payment issue, and a number of complex arguments from both sides, and he just ended up doing a 50-50 split because he just simply didn't have the time to consider all of the issues and investigate all of the facts. So to me, the biggest risk is rough and ready, but then you still have the fallback to ultimately refer it to litigation or arbitration.
Duncan, be interested to hear your thoughts on this.
Again, quickly, and I'm just passing on things I've heard because, like all of you in the audience, I have absolutely no personal experience. So I'm just really parroting what I heard in this case from Justice Colson. He wrote it in his book too. If you're interested, there, he's written a book on adjudication process that is just an amazing piece of work. It's a good starting point for everyone in Ontario. But he said there were initial quality concerns, but because he sees things that get into his court, he says, as far as he's concerned, the quality of adjudication now is high. The quality of the awards that he sees is very high. He's impressed. And it's the market that sorted it out. Again, it's the industry that sorted it out. Bad adjudicators didn't get work. Good adjudicators did. Bad determinations got attacked on due process grounds and got overturned. So the market, God bless this market, it sorted all that out. Independence and impartiality concerns are a big problem. Repeat referrals to the same adjudicator, that kind of thing. The splitting the case in the middle problem was identified. But a new concern, one that I didn't think of until this morning, and I went over my notes of my meeting with him, was he said what they're seeing now is many more cases of collusion, bad documents, backdated documents, in some cases fraudulent documents. The emphasis on the documentary file has driven people, I think, to do things that now one sees. We've seen in our firm this year a case where there were actual altered documents. It's not like that's unique to adjudication, but this is something he said the emphasis on documents is now forcing this to deal with.
So how do we mitigate some of these risks? You've all spoken very usefully on what those risks are. I'm wondering, how does a party going into an adjudication deal with those? Chris, why don't we start with you?
From my perspective, the thing that immediately comes to mind is for the parties to improve their contract administration. And from my experience in Canada and elsewhere, it can vary from party to party. So I tend to find the very large contractors working on large projects can be very good at keeping records, making sure the records are kept contemporaneously so they don't fall into problems that Duncan mentioned. And it's also how they organise the records as well, so that it's making sure they're well ordered, that if they're stored electronically, they're easily accessible. So that if they need to appoint an expert or when the lawyers come in, they can very easily transfer the information. The key documents can be found very quickly. To me, that's one of the key things to assist from a documents point of view. From an expert appointment point of view, it would really be to, certainly on large projects, to appoint the expert early. So the expert's got an understanding of the project, of the issues that have occurred. Because if you're trying to parachute an expert in at the last minute, he's got a very steep learning curve to go through. So from my perspective, it's the better contract administration and the earlier involvement of the experts.
Those are very important points. Thanks, Chris. Fleur, from your perspective, how do you mitigate risks involved in adjudication?
Yeah, and I think the appointment of the adjudicator, Duncan's spoken to a bit, but one of the things that we did in the UK was work out whether at the time of signing the contract, we could pre-agree adjudicators. So whether we could kind of put a list together of 5 adjudicators that we'd all agree to, that if a dispute did go to adjudication, we would use those adjudicators. And then the other point that I spoke to as being a risk is the point about the adjudicator properly understanding the dispute. And I think that the way you get around that is just making sure that your documents are very, very focused on the key points. There's not a lot of time for a great deal of detail in terms of adjudication, so making sure that everything's very, very focused on those key points that you want to get across, so that the adjudicator can see the wood for the trees in that respect. And then just going off what Chris said in terms of experts, I think that probably also applies to lawyers. You know, if something's got the hint of going to an adjudication, the early involvement of lawyers as well is important.
Duncan, can you tell us from your perspective, how do parties mitigate these risks that adjudication might bring?
I don't know how parties do, but I have a sense of maybe what we're going to do to deal with it here. So tip of the hat to Keith Bannon, who serves, and I wrote down, we're going to ride the cosign of UK experience. We're going to learn from the almost now 20 years of experience, 1998 to 2018, almost 20 years of experience that we have in the UK, which is very helpful. One of the things that I think we need to look at is what Fleur just mentioned, which is although we prohibit parties from naming the adjudicator in their contract, allowing parties to do strike lists. So to include, each side could add 5 names to a list, so you have 10 names, and at least you have a strike list there. I think the nominating authorities and courts would probably be happy to see that. So I think that's one way to mitigate risks. Reynolds and Vogel touch on this. A key part of the report is training and education of the bar, the bench, and most importantly, adjudicators. They're section 13.3 of the statute actually incorporates that as a directive. So the government and the arbitration nominating authorities will have to develop and oversee adjudicator training, qualify people to meet prescribed requirements. This is to address the quality issues. This is a global phenomenon. Canada and the US are the last common law jurisdictions to look at this and start to bring it in. So we've got a lot we can learn from. The idea of maintaining a public registry of adjudicators is right in the statute, and there'll be regulations that will do it. So I think that will all help to mitigate the risks that Chris and Fleur have experienced.
Thank you. As with any system, there's going to be people out there who want to try to game it, try to take advantage of what the rules and regulations are. Duncan, as somebody who's involved in drafting these rules and regulations, I'm wondering from your perspective, is it going to be possible to game the system, and if so, how?
It always is. It always is. I mean, that's in a sense our profession. So, yes. There will be a strategy. Let's call it strategy for want of a better term. There will be strategic approaches. Clients will expect that they'll be entitled to it. There'll be lacunae in the statute that will be exploited, and there'll have to be holes that will be plugged. We're going to see all of that. We're going to see what our friends in the UK, the sort of Christmas Eve notice of adjudication, which sort of Chris can speak more to. We're going to see all kinds of things. We'll see the profession change. We'll see people becoming specialized in this, and with that will come some art in the practice of adjudication. One of the sobering aspects is that you can have consecutive adjudications with the same adjudicator, so that there's no stranded risk there, and you can also bring in a bonding company. And those of you that are familiar with Bill 142 see that the statutory requirement for public construction will be for bonds, either 50% performance and payment or 25 or some percentage. It looks like that's going to survive third reading, so there will be a mandatory bonding requirement. And if I can just go on for 1 second,
Please.
I think why that will avoid gaming is the almost always overlooked benefit of bonding, which is unique to the North American market, really. You get the expertise of almost not quite independent. You get the expertise of claims adjusters who are highly experienced and highly motivated because now they'll be involved in adjudications to get in the middle and make the problem go away. So I think that in our jurisdiction is going to take out some of the gaming. And the final sort of piece to show that the report striking the balance looked at this is the preemptive litigation arbitration. The drafters already looked ahead in Bill 142 and said, you know what, I know what's going to happen. Because we're bolting this into a lien, someone's going to start an injunction application, commence a lawsuit, preempt and have the court seize jurisdictions. You can't adjudicate it before the courts. Section 13.55 removes that, right? So at least that's one game we can play.
Thanks, Duncan. Flora and Chris, I'm wondering if you can tell us a bit about your experience in the UK. What games are played and how do parties try to deal with those? Chris, why don't we start with you?
Okay, well, we touched upon the ambush as it was in the UK, where the party was spending time preparing its claim and submission to adjudication, and then they would typically submit it on Christmas Eve in the UK, just ahead of the holiday period, which would put the responding party under tremendous pressure. I think the adjudicators got wise to that and they figured it out. So very often the adjudicator was appointed, he'd say, okay, well, I'm not available between these dates. And so it just get pushed out. So very often the adjudicators were able to manage that and get around those issues. And I think initially as well, soon after the legislation that came in, the party received a referral, then very often they would attack the jurisdiction of the adjudicator, and there would be multiple grounds that could do that, whether the dispute had crystallised yet, whether it was actually caught by the Act, so projects were excluded. So that was a sort of a key approach to sort of say, well, okay, you refer this dispute to adjudication, but it's either too soon or it shouldn't be referred to adjudication. But I think over time, I think those that they've worked their way through the system. There's been a number of judgments in the UK that have clarified the law regarding that. But as Duncan said, there's going to be a time period where there's going to be different kinds of arguments to see how it can be tested.
Or could you tell us a little bit about your experience of people trying to game the system and what you did to deal with that? Or maybe what you did to perpetrate it?
Yeah, I agree with everything that's been said so far. We had a slight extension of the Christmas Eve kind of ambush, and about 10 years into adjudication, there suddenly became the kind of the summer vacation ambush. So people would realise that people were going to be away over the summer period in the construction industry, and it worked out as 2-3 weeks where you can kind of maximise that. And we started to get a flood of adjudications through kind of in the summer period. Quite interesting. And then in terms of the jurisdictional issues that Chris spoke about, we experienced that as well. So when adjudication first started in the UK, nobody really had any sense as to what jurisdictional issues could be raised at that stage. And then a kind of slowly a body of case law came out that interpreted different things different ways. And people really took advantage of that to raise those issues and to try and use those issues just to buy some time. So you raise a jurisdictional issue. And then that would buy you some time until you can start the adjudication again. So there was that. And then in terms of the responding party, there was a system where you couldn't go to adjudication until the dispute had crystallised. So until one party had said, I want X, and the other party had said, no, we're not giving you X, you couldn't go to adjudication. So if you thought you were going to be a defendant in adjudication, what you would do is rather than just say, oh no, we're not giving you X, you just ask for lots of information, you kind of keep that chain of correspondence going so that you can prevent the adjudication from happening. Because if it did happen, then you can say the dispute kind of crystallised. I think we can have comments to say on that.
Not really.
Oh, okay.
Actually, Duncan, I was going to ask you, Flora and Chris both made the point that parties in the UK would try to lie in wait a little bit with their claims. Is that going to be mitigated in Ontario to a certain extent by tying adjudication to the idea of the delivery of a proper invoice and the necessity to bring forward an adjudication if somebody's delivered a notice that they're not going to pay you?
Yeah, we're going to be very clear about that. So adjudication is not tied to prompt payment. Prompt payment in a way is tied to adjudication. So I mean, so that jurisdiction under 13.5 for adjudication is rather broader as we looked at. The prompt payments included. The idea is to get money flowing, but adjudication is broader. Anybody who supplies a lienable service could adjudicate any of the issues in 13.5. So it won't be tied to prompt payment. One thing though that Jay, that I should have added, and it's subtle, it's in the statute in 2 places as it now reads, and it may stay there, but it refers to abusive process and proceedings not conducted in good faith. The parties bear the costs of adjudication unless one of the parties has acted in abusive process or in not in good faith, as opposed to in bad faith, I guess. What that means will be a matter for someone. It's not clear in the statute if that's a matter for the adjudicator in the determination, and if somehow post-determination or pre-delivery of the determination, that issue will be determined in the determination, or whether that will somehow be an enforcement matter. So when someone goes to a court to enforce, the court will chastise somebody for their conduct. That's unclear now, but I think, Jay, on the topic you're discussing, that's going to really to restrict some of the fun and frolic in gaming system. And adjudicator shopping, Chris, did you see adjudicator shopping in the UK? That's something that I heard about and I don't fully understand, but the idea of hoisting the jurisdiction of the adjudicator you didn't like, waiting for one you did like. It happens in the judicial system. I don't know, does it happen with adjudicator?
Yeah, in my experience, some parties certainly had their favourites.
Yeah.
And I saw it from working in the company who had a number of people who were acting adjudicators. And if a decision of theirs was challenged in the courts, their name would become public. So one of my colleagues was the first person to have his decision challenged, and there was a big article in the press magazine, Mr. Adjudicator, and all of his colleagues were jealous, because he got that public exposure. And that led to an influx of work for him.
There's no such thing as bad press, is what you say.
Fleur and Chris, based on your experience in the UK, what would you recommend that a party use adjudication? We've talked about some of the risks, but ultimately adjudication has to make sense for some parties. And what considerations do you think are relevant for a party in making that decision? What should they go for? Fleur, why don't we start with you?
Yeah, I suppose in terms of the decision to go to adjudication, I think that you'd want the parties to have had a chance to resolve it between themselves before you went to adjudication. So I think that's a consideration. Is this something that's resolvable by the parties just speaking to each other and sorting it out before going to adjudication? But then another consideration, I think, is how complicated is the dispute? Is it something that an adjudicator is reasonably going to be able to get his head around in that very short time period? And there's some kind of disputes that you just wouldn't want to risk that with. So that would always be a consideration as well.
Chris, do you have anything to add to that from your experience of when parties decided, let's go to adjudication?
Certainly from a contractor's point of view, the sooner the better. It's kind of like a cash flow. And certainly on large projects, I would think contractors who are involved in the very early part of the project, I think they'll be key to launch adjudications. But other factors come into play. I think when Claude's made about complexity issues very, very important. And also, you've got the availability of the staff, cash needs within the business, within a particular financial year, the organisation of documents, the evidence. So I think there's a number of factors that could come into play.
You just touched on the organization of documents, and that may be one of the things leading up to an adjudication that parties want to think about. Can I ask you more broadly, what should parties do to protect their interests before an adjudication starts? Chris, why don't we start that with you?
I think before an adjudication starts, to many of the keys, just making sure you're keeping the right kind of records, to make sure they're organised well so they're easily accessible and understandable, to make sure that they can be shown to be contemporaneous. Very often I see contractors recording, say, trade labour returns just in a spreadsheet. And the risk of that, if that's not communicated to the party, is that can be shown later as being a document that's prepared retrospectively. So to me, it's the keeping of the right, the most appropriate record. But there's a balance to strike as well. So say for the smaller subcontractors, they might not necessarily want the heavy burden of very detailed document record system. So it's really striking the right right balance. But certainly, better records, better organised, more easily accessible.
Fleur, from your perspective, how should parties prepare for an adjudication before it's started? How do they protect their interests?
Yeah, I echo what Chris has said there in terms of document organisation. I think parties won't do so well at adjudication if they haven't kind of got their documents properly organised in that way. But I think another important consideration is not just getting your documents organised, but making sure that you've got the right people available, that people aren't going to be on vacation at the time that you start an adjudication, because it's such an intense time period, both for the lawyers, the clients, that you really need to make sure you've got everybody available that can kind of point you to the right documents as you move throughout the course of the adjudication.
Now, can you tell us your perspective on how parties should protect their interests before an adjudication starts?
Yeah, I'm happy to speculate on that. I would defer though very much to Chris and Fleur on this because they've been there and done that. So the first point that strikes me as just the key takeaway on this point is documents, making sure that your document management system, make sure your contract administration is respected. Right? I do know that, you know, when you're arbitrating a dispute or where you're litigating a dispute, you look to see how people conform to the names of the documents. You know, is it a change directive or is it a change request? You know, is it in order? Is it numbered? Is it completed? If there's signatures at the bottom, are they there? This will become vital. I think that's healthy for the industry. I wonder if you share that view, Chris and Fleur, but I think in the end that focus on contract administration ultimately makes everybody's life a little simpler. And training, obviously in education, law firms are going to have to do a lot of that with their clients. The word I would use is the democratization of disputes. It's no longer the priesthood of lawyers that gets to do it, or consultants, or senior client in-house counsel. It's really a collaborative, you know, that's a word I like very much. It's a collaborative approach to getting a case ready. And then managing client expectations. It's always difficult for people who are leading a dispute resolution effort to manage their clients' expectations. So, you know, through a litigation process, the client's entitled to be told, do I have a good or bad case? What's going to happen? How do I plan for Q1, Q2, 2018? Are we going to be, you know, all those? I think that becomes much easier in a, I would expect, in an adjudication environment because it's quick and dirty. You know, you can't make promises. You can just do your best and see what happens.
You've all spoken about the importance of document management, document organization. I'm wondering, what are the key documents that you think parties need to have available to be effective in an adjudication? Duncan, your perspective is as an arbitrator who's heard many disputes, whereas Chris, you've been involved in these adjudications in the UK. So I'm wondering if you can all share your perspective on how does a party paper the record appropriately? What are the key documents they need to make their case that need to feed into that organized document system? Anybody can take this.
Well, I mean, I'll be short. So I think I just said it. If anyone in this room is tasked with deciding a dispute, you're going to take the most trustworthy route, which is to look at the contract, see what the parties said they were going to do, and then measure a party's performance against that standard. So if it says notice is going to be given and it's going to be in writing and it's going to be in the form that's Schedule 23 to the agreement, then I think we would all turn to Schedule 23 and compare it to the document at hand. So my simple answer would be think about it at the time of contract formation, simplify it, make sure your people do it and watch that. That's what all I've contributed.
Yeah. I think the other thing that I would add to that is if there's been any kind of verbal agreements throughout the course of the contract that you want to rely on during the adjudication, and to just make sure that those verbal agreements are all somewhere in writing, whether it be a letter, whether it be a file note, whatever it might be, just making sure that any of those agreements have been made throughout the course that you want to rely on, that they're properly papered somewhere.
Chris, your perspective on this?
Sort of to build upon exactly what just Flora said. And so, for example, we know the scope is going to be concerning payment disputes. So, for example, if you have a dispute over the quantity of work that's being performed, then parties should document and seek an early agreement on that. So, the contract administrator should be able to get together and record exactly what quantities of work are being performed. So, there can be closer collaboration between the parties to make sure that they've both got good sets of records to avoid disputes in the first place.
Going into an arbitration, or rather an adjudication, a party's relationship with its lawyers and its experts will obviously be important. I'm wondering how adjudication will affect how construction companies structure their relationships with their lawyers and their experts. So I'm wondering if you can tell us a little bit from your perspective, somebody who's been through this as counsel in the UK.
Yeah, I mean, I think that lawyers are probably going to be a lot more involved over the lifetime of a project rather than just at the end. I think it's a different type of lawyering when you're involved in adjudication. There's less focus on getting the documents perfect to the detail and much more focus on ensuring that the adjudicator can see what it reads and getting your point of view across. So I think that that's going to change the role of a lawyer in that way. I think that you're writing for different audiences, and adjudicator can be legal, have an engineering background, all sorts. So you kind of got to bear that in mind. But I think the key thing in terms of the lawyer kind of client relationship is dealing with the dispute in real time. It's a short but very, very intense period of time. So I think it's kind of a good opportunity for lawyers and clients to kind of have stronger, deeper relationships with each other, because you're both working on this adjudication in this very short, kind of intense period of time. So I think that's probably where we'll see a key difference.
Chris, from your perspective, how did adjudication change the relationship between, or will it change the relationship between a construction company and its experts?
I don't see so much as the relationships changing with the experts, because I still think there needs to be the independence of the experts. So the risk is, if you appoint the experts earlier, then they become so close to the project team, and they sort of more adopt the claim argument, what the project team considers is the answer. So there's a risk there. You'd want them involved at an earlier stage to become familiar with the project and the issues, but not too closely involved. So I think there's an element of striking the balance.
Duncan, if you look into your crystal ball, how do you see the role of lawyers changing in Ontario?
Well, looking into the crystal ball and picking up on what Fleur and Chris have said, which I agree with completely, the relationship will have to be between lawyers and the clients intensified during the course of the project. I think what we'll see is a change in the form of retainers, though. I think we'll see more limited scope retainers, which the Law Society now permits. I think we'll see perhaps specialist people in certain kinds of adjudications brought in to help a team. So if there's a set of commercial lawyers that are running a major project and they need spot advice, I think we may see some limited scope retainers there. And I think that the people that will do, but the hard thing I think for firms now is going to be training young lawyers. I think that's going to be something that will be a legacy of adjudication that nobody can predict. It's hard enough now with mediation and arbitration to get courtroom experience for young lawyers, which I still think is vital to the idea of advocacy. I think it's important. And I just think the opportunities for that with adjudication might be fewer. It will be, I think as Fleur and Chris both say, a different kind of representation. So I think looking ahead, that may be something.
Fleur and Duncan, there are some in-house lawyers in the room, in addition, of course, to you, Fleur. I'm wondering if you could tell us, how do you think client expectations should be managed during the process of adjudication, and then with regard to the uncertainty of the results that you've spoken of?
Yeah, I think all that can be done is to point out to clients that there is a lot of uncertainty in the process. I've had adjudications before where I really, really thought the client had got a really strong case. We've done absolutely everything we could to kind of project that case to the adjudicator, but we still got the wrong decision. So that can happen despite everybody's best efforts. That's got a real prospect of happening. I think just making clients aware of that fact at the beginning is important. I mean, adjudication sounds great for clients. You can adjudicate soon. It's relatively cheap to do. You get a kind of a decision quite quickly, but it does come with a lot of risk. And I think just making that apparent to people at the start, before commencing the process, is really important.
Duncan, anything to add to that?
Well, I agree with everything Fleur said. I think that the problem for our profession will not come, and managing expectations will not come at the level of Carillion or the level of LSL or at the level of PCL or any of the big players. I don't think it will come at the level of the sophisticated international mechanical electrical contractors. I don't think they'll get it. I think where the problem is going to come is, two Joes with a ladder on their truck. the person that renovates schools and does asbestos abatement. I think we're going to see a real need to manage their expectations, because I think they'll be confused about the quick and dirty concept, right? When it goes their way and the check comes in 10 days, they'll be thrilled and think, boy, we should have had this 20 years ago. When they're told, no, the extra 200 truckloads of contaminated fill are on your nickel, because that's what your contract said, I think they'll be less happy and more inclined to have their lawyers go back to the books and say, well, was there a breach of due process? Did they really understand their contract? You know, I think we're going to see some of that. I think that's the real task. It's not at the infrastructure level. Let's put it that way.
With regards to those sorts of risks, how do parties protect their interests after an adjudication has started, when they're in the process? For instance, how do you coordinate commercial, legal, and expert resources? Chris, maybe you can talk a little bit about this from your perspective as an expert.
I think there needs to be closer relationships, because you've got to work together in such a short period of time. So, and I think certainly for the experts, there need to be a clear explanation of exactly what's required from the experts and the timelines for it, because they'll need to be really focused on giving an answer that really suits, that is really aligned with disputes. So I think overall, I'd say sort of clear deadlines, clear roles, and closer working relationship.
Fleur, how do you see that coordination playing out on the legal side?
Yeah, I mean, I'd echo what Chris says. It's all about people being flexible. Because whereas in litigation or arbitration, you've got a set process, you know what's going to be happening, you know when it's going to be happening, you've got a reasonable time period to work towards that. In adjudication, you've got a much shorter time period, and there's a lot to be done, and you don't know what's going to happen exactly during that process. So I think just making sure that everybody is available to assist as and when required is important. So there's a lot less ability to have some kind of structure to it that you would with litigation and arbitration. So I think flexibility is key.
Fleur, you have uniquely dealt with a lot of the internal cash flow and budget issues for a company involved in arbitration. How do parties budget and manage cash flow appropriately in the case of a series of adverse decisions that might have an impact over the course of the project?
So in terms of adjudication, it's quite expensive in the sense that you're tying up internal resource for what's probably a month period. There's also the kind of the costs of external lawyers and consultants, and it kind of takes the dispute out of the party's control. So in terms of, I think the question was about managing budget and cash flow and all the rest of it. So the key thing for me is to try and avoid adjudication, because then that avoids the risk. But in the sense where you are going through an adjudication process in terms of managing that budget, I think it's just as Duncan was saying, in terms of trying to get a short term. I think what kind of word you use for it, a kind of short term retainer.
Yeah, a limited scope retainer.
Limited scope retainer, that was it. Yes, to manage that.
What if the worst happens and decision adjudication?
Just before we go to that,
Please.
just to add, if I can, Jay, to what Fleur is saying, from the law firm perspective, the external counsel's perspective, it occurred to me in preparing for this morning that we've done this before as a profession, because anybody that's been involved in an interlocutory injunction, anybody that's had to stop someone from picketing or stop someone from making noise or stop someone from removing equipment has done this before. This short cycle, intense period of preparation. It struck me that what we're talking about in adjudication might be a slightly scaled down version of it, but it's not too dissimilar, where you have to manage expectations, you have a difficult standard to meet, you have to assemble a team, and it has to be devoted to something Fleur said earlier. It can't be people that spend 2 hours on this file and then 2 hours on that file and then 2 hours in the weekend on something else. It's going to require us to during the adjudication process to be absolutely focused on that, right? For that matter. And that's what it feels like in a law firm when you're doing an injunction. You know, the pickets go up and you've got to get them down and get the trucks across. Then it's all hands on deck. It's from Wednesday until Sunday, and it's 5, you know what I mean? So I think I think the profession needs to take that skill set, which they have, and apply it, scale down perhaps to this process.
So, as we all know, sometimes the worst can happen. A decision can go against you. Duncan, if a decision is found against a party, can that party appeal or seek judicial review of an adjudicated decision?
Well, I have two things to say about that. One is to answer your question and then tell you what Justice Colson said. So to answer your question, you're going to get a stinker. You're going to get the site was supposed to be a greenfield site. Turns out there's an old historic dump in the corner, and it's 200 truckloads of contaminated. You're going to get that case, and you're not going to like the result because someone's going to get told, "I'm sorry, that's on your nickel." So what you do is this. In fact, there's no appeal. So if you don't like what happened, you don't get to say, "Well, let's place that. We're going to go to a judge in the Superior Court to get that set aside." That's not how it works. You have to apply to set the determination aside, and the jurisdiction for that is extremely limited. It's under Section 1318. It's by design extremely limited. So for the room that's familiar with arbitration, you should think of it like the model law grounds for attacking a final arbitral award. Very, very hard to do. So it's one of the highest of bars to cross. So you have to be quick about it. It's within 30 days of the determination you have to attack. We don't know yet where that will go. Frank Morocco, the Associate Chief Justice, is looking at that issue, and that will be, of course, in the rules or regulated. It looks like it's going to go to the divisional court. It looks like it may go to a 3-judge panel. For the non-lawyers in the room, our divisional court is a part of the Superior Court, the trial division, that sits on appeals from interlocutory decisions. So people familiar with the Construction Lien Act will know that that's where construction lien appeals initially go. So within 30 days, it may well be a 3-judge panel, but it will be what I call model law grounds. So legal incapacity of the party entering into the contract. Maybe the 2 Joes and a ladder in the back of the truck might be able to argue that, but I don't see that working for other people. Invalidity of the contract. That's interesting for me because it ties into the subject of termination of a contract. Everybody in the room is sensitive to the idea of terminating a contract as opposed to terminating the right of a party to continue with the work under CCDC. I wonder if you terminate a contract, if you could then have recourse to adjudication. I think that would be an open question. Excess of jurisdiction for the Latin scholars, ultra petita and infra petita, going outside your remit and not deciding all the issues that were given to you, maybe something that you can complain about. One that's interesting that Reynolds and Vogel added in was delegation to someone other than the adjudicator. So for those people who see adjudication as the great second act in their career, third act, they have to be careful because you need to do the work. So if Fleur and Chris hire someone to do the adjudication, then they have to do the work. They can't have a friend who's an engineer help them. They can't have their legal researcher help them. They can't have somebody else write it, right? So I can see that being, for a lazy adjudicator, I can see that being a problem. Not following procedures and reasonable apprehension of bias. I worry about that one. That's opening the door because there'll be all kinds of things and it'll be unpleasant to see, but we'll see those come up. So that's what it is. Now, the Justice Colson thing, will stop. Peter Colson, quite a remarkable man. I had the pleasure of meeting him and talking to him about this. And he's just a classic judge, if you get what I mean, just a classic. He's used to be right all the time, whatever. So and he's just a wonderful man, so smart and so intelligent. But he just put his hands up like this, and he just waved his hands. He said, "Oh, these things come," but he was like he was chasing flies. He said, "Oh, these things come before me." He said, "I don't pay attention to them." He said, "These are interim decisions. They all disappear. And if somebody has a problem with it, they'll bring it back to the court system, and I'll see it that way." So he waves the way. So I think that I proposed to him that we have him over here to speak to our bench because I think the cooperation of the judiciary in the introduction of the adjudication provisions of this amended statute is going to be crucial. Because if we don't have the court system behind us, as I'm sure Flo and Chris will echo from the UK, if the court system doesn't back it, then it is going to fall apart and people won't trust it and it won't work. So that's what he said. And I believe in the end, that's what our court will do. If you look, sorry, he said it was short. If you look at what our Court of Appeal has done with final arbitral awards, I believe I'm safe in saying in this room that finality is a principle that our appeal courts in this province really get. They say if you're going to choose private dispute resolution and if you're going to pursue it, then you better like the result because we're not going to interfere with it. And I think that's what we're going to see.
Thanks very much for that, Duncan. Another question for you, Duncan. What happens if a party doesn't abide by an adjudicator's award? For instance, they refuse to pay an amount that's been ordered.
Nothing is really of much use as it unless it's enforceable. So in international commercial arbitration, you're always worried about, fine, I get this award, I spent X to get it. How do I enforce it? Where's the assets of this person? It's a little different. This is something that the Reynolds-Vogel people report really looked at. 1319, section 13.19 is the section. So if you get a determination, the theory is you must be paid within 10 days of that determination. What if you're not paid within 10 days of that determination? Well, wonderfully, if you're a subcontractor or contractor who's supposed to be paid the money, you can suspend work. Right? Suspend work. You're still bound by your contract. You still have to perform your contract, but if you're not paid a determination, you can suspend work. Imagine what that would be like for most of you in this room on the substantial jobs you work on. It's almost unthinkable, right? If you stop a big complex engine like pick your project, it doesn't matter. Imagine something on the Eglinton LRT that Metrolinx that's suspended because there's an unpaid determination. Horrific. It's expensive to wind it down, and it's more expensive to wind it back up again, and there's long-term consequences. If that happens, the person that had the right to suspend work recovers not only the determination, so the 3.7 million they were supposed to be paid, but interest, mandatory interest on that, the contract rate or courts of justice rate, and this is where there's a big add-on, the cost of suspending the work. And don't ask me how broad or wide or tall that is because no one knows. It's there. It's in Bill 142. I think it will survive through reading an enactment, a proclamation, and it will be a very interesting provision. You can also go to a court, right? You can also take your determination to a court like you could a final award and enforce it. I think if we got into costs of suspending the work on a big infrastructure project by a sub, let's say a piling sub, it's unthinkable. And I think those costs could far exceed the matter in dispute. So it's a coercive measure to say to people, sober up, smarten up, read the statute, pay the determination and move on. And I'd be interested in the UK. I think people do respect it. Do they not in the UK and make payments?
Another very quick question for you, Duncan. We're all familiar with cost awards in court proceedings. Are there going to be similar provisions in adjudication in Ontario for a successful party to be awarded some of its legal costs?
Well, not really. It's sort of half yes and half no. So presumptively, parties bear their own costs, Jay, which I strongly favor. I think that's good, unless there's some abuse of the process or someone has proceeded, as this wonderful expression, not in good faith, as if that's the distinction from bad faith. So if there's been a sharp practice, high-handedness, if the adjudicator finds that all those 3 letters you sent were all, the ink is still wet, right? Those weren't sent in 2017. Those were made last week. That kind of thing, I think, will attract cost consequences. The open question in my mind is how that emerges and who it is that makes that determination. It's unlikely that will emerge before the adjudicator. So I think we've got an area there where regulation is going to have to help us with that. But short answer is presumptively everybody bears their own costs unless somebody's misconducted themselves.
Thank you, Duncan. Flora and Chris, I'd like to understand a little bit more about the role that lawyers and experts play in the adjudication itself. And we did touch earlier on the importance of coordinating legal and expert resources. But Chris, I'm wondering if I can ask you, we all understand how experts are used in the court system. Can you tell me a little bit about the role that experts play in an adjudication in terms of providing expert evidence, assisting in making the determination, and how a party should, in your mind, best make use of its expert resources to get the best result for it in an adjudication?
So I think in Ontario, because of the provisions of the 142, I think the focus is going to really be more on quantum experts. I think there's going to be arguably no or limited scope for delay experts or any other technical experts. So I think the majority will be quantum experts. And I think they can have an early involvement, going back to what we were saying about record keeping. So advising the client on the records that they should be keeping, the records that should be there, that they should keep. But then I think when a dispute arises, they can be involved at an early stage to give their opinion. So it could be that the contractors or the parties submitted his position, he's got the opposing party's response, and you could seek at that stage a very early opinion from the expert, because you could find that the expert actually agrees with the opposing party's expert. So look, this is why they valued it in this way. So if I were to give an opinion on this, I would perhaps have to side with the opposing party, and that could just kill the thing dead, stop it being referred to adjudication. So I'd certainly say, going back, a much earlier involvement, but also earlier opinions as well, just so a party has a clearer understanding of his position and what the expert will say if it's referred to adjudication.
Fleur, what's the right role for lawyers to play in an adjudication, and how, in your view, is the role of lawyer going to change with these more fast-track adjudications becoming the norm?
Yeah, I think I've touched on this before. I think that the role of the lawyer will be less detail focused, and there won't be as much time to review absolutely everything that you normally get. But if you saw a dispute through a kind of court process or an arbitration, so I think it'll be much more of a kind of commercial lawyering rather than detailed lawyering, and it'll be concentrating on getting to the key points very, very quickly and working on how to present a case where it's going to be in this fast track situation rather than the much longer term situation where you've got a longer period of time for a judge or an arbitrator to get familiar with the dispute. So I think there'll be kind of, and I think there'll be an all in it together feel as well that comes from lawyers and clients working together in a kind of very short time frame. I think the language used in claims won't be legal language, it'll be more commercial language. You're writing for a kind of different audience in different circumstances. I think also that maybe mediation will become a little bit more popular. So perhaps the lawyer's role will also kind of extend to doing more mediations, assisting clients in mediations, because there'll be that threat of adjudication that means that clients will prefer to do a mediation much sooner than they would have otherwise. So I think we'll see the kind of disputes environment just get a little bit more collaborative and a bit more settlement focused as well. I think that the lawyer's role would be to help assist with that.
Thanks, Fleur. Duncan, you mentioned at the outset that the adjudicative provisions in Ontario live within the lien statute, which is sort of a unique feature of Ontario adjudications. What's going to happen to lien actions and arbitrations after parties have already been through adjudication? And how do they interact with one another?
I was just busy scribbling down a note for emergency mediator. Thank you. I'll give you credit for that. I like that idea very much and made a note of it. But to answer your point, Jay, it's a serious question, and I opened with that at the very beginning, the striking the balance document, the Reynolds-Vogel document, and you used the term, I think, Chris, in your answer at one point, striking the balance. It really was designed to do that. It was not to upturn the lien apple cart or the trust apple cart. It was to embed within that statute a more summary dispute, I call it avoidance, but dispute resolution mechanism. So you don't lose anything, right? There's no net loss to the industry. Your lien rights exist. They're modified a little bit and modernized, is what the report calls it. The time periods are extended, and there's some other tweaks and tunes. But you still have your lien rights. You still have your trust obligations and your trust rights. You can still register a lien check. You can still preserve and perfect that lien. There still will be lien actions. There still will be people vacating liens. There's been some questions, Master Albert I spoke to about this, and she's really wondering about that. She said, well, what do we do with the determination? You know, she said, look, somebody from your office is going to come trotting in to vacate a lien, and let's say it's not a $100,000 lien, it's actually a $20,000 lien, and here's the determination that found that. And she said, what am I supposed to do with that? Because I know it's quick and dirty, and it wasn't made on a great record, and it might not have been someone legally trained to make that decision. So these are some open questions. And this is open to abuse. So the man with the truck that would have the extra 200 loads of contaminated fill to deal with is going to be unhappy, and he may well register a lien for the value of that work. And it may mean that the owner has to deal with that. Nothing there will really change. The statute, though, in its tweaks and tunes, does address the over-leaning. It introduces this concept, again, of not in good faith, as distinguished somehow from bad faith, but it introduces that concept in the over-leaning provision in an attempt to change the nature of the discussion, right? So it's not just an empirical discussion as your lien was worth 20 and you lean for 100. It goes more to the commercial intent behind the lien, more of a kind of SAFA thing. So that's a long answer to a short question.
Fleur, based on your experience in the UK, are we going to see a decline in litigation and arbitrations at the end of the project? Are parties going to relitigate the issues, or are they going to live with the decisions that they've been bound with on an interim basis going through the project?
Based on the experience in the UK, I would have thought that parties would probably live with the decisions. That's a short answer to a short question. So.
That's great.
But yeah, I mean, that was certainly my experience in the UK. Was people tend just to live with the decisions because it was better than going through a more painful process.
Duncan, another question for you. There are often interrelated disputes between an owner and a general contractor and a general contractor and a subcontractor. How are the adjudicative provisions going to deal with multiple parties and multiple issues going up and down the pyramid?
Again, I'll answer that, but I just want to add to what Fleur was saying, and something Chris mentioned, what Chris mentioned earlier. The experience of the people I spoke to was that there's on a big, long project that's going to take a couple of years to perform. There's an interest in adjudication in the beginning. There's a few sparks are let off early in the process. Parties do it, accommodate, and there tend not to be a lot of adjudications of those projects later. But to your question, this is dealt with in section 13.8. It's a very, very important point. I would note it under the heading, no stranded risk. So if you are a contractor or a subcontractor and people below you, and the issue, let's take my loads of contaminated fill issue, that percolates all the way up. The excavator finds it, the former contractor has to live with it. The invoice goes up to a sub, to a contractor, to an owner. What do you do with that? If you look at the statute, it's very, very interesting. Like the UK, the adjudicator can only deal with what's called a single matter. So this example of the fill might be a matter. But section 13.8 goes on to say that the same or related matters in respect of an improvement can be consecutively adjudicated. So that would mean to me that the fill issue, percolating up to a former contractor, to a sub, to a general, to an owner, there could be a series of consecutive adjudications. And I won't bore everybody by reciting it, but if you look at the provisions in Bill 142, it deals with that. It deals for consecutive adjudications held by a single adjudicator in a row. It allows the parties to agree to do that. It also allows the contractor to require that, right? Because the contractor is not going to be the meat and the sandwich, right? You have to be able to do that. And you also will see, if you look at it, a careful provision so that the obligation to pay within 10 days and the draconian remedy of withholding performance only locks in after the determination in the last of the consecutive disputes, right? So you don't get someone stranded with a withholding of performance because it's 10 days after their dispute was determined, but the poor general contractor is stuck, 30 or 40 days later resolving their end of it. And when you think about it, that makes sense. Jen, so sorry, I keep going on and on, but when you think about it, it makes sense because everybody's contract is going to be different, right? The guy that did the excavating might just have a purchase order for truckloads. And he'd say, well, it's different because I was supposed to do a 2-kilometer run. I now had to go 20 on each run to the landfill for weight. The contracts could be different. Subsurface risk could have been taken on by the contractor. The contractor could have done a design build and said, I know what's under there, but I'm going to take that risk. So long story short, it's provided for in Bill 142. It's, I think, a sensible regime. It bears reading. What will be interesting to see if in performance it actually works. Right?
Thanks, Duncan. This is going to be the last question for me, so I'll prompt those listening by webcast. If you have any questions that you'd like to ask the panel before we wrap up, please type them into the dialogue box, and Ariel, our articling student, will assist me in passing them on to the panel. But last question for me, how do contracts need to change to deal with adjudication? Duncan, why don't we start with you?
Well, they're going to have to change in a number of ways. The Canadian Construction Association, the CCDC committee, is already looking at that for their standard forms. Remember that maybe it's all we have time for, but like the UK, it was a great idea in the UK, and we've adopted it. Our adjudication provisions are minimum procedural standards, right? So yes, this is what the minimums are, but the parties can agree in their contract to tweak and tune them. I'd be interested, Chris, if you've seen this, but I hear now, I heard when I was over there in May, that 3 adjudications are actually happening. So on big, thorny issues with a lot of money, there's 3 adjudicator panels to be set up, which is, I think, permissible in the UK. And we may see that here. So if it's Metrolinx and it's some complex issue, environmental / delay, I don't know what it would be, invoicing issue, you might need or want to make it enforceable through adjudicators. So the point is, contracts may improve on the minimum system that's in the statute. I think we'll see that. And I think the rest of Canada is watching. I didn't bring it with me. There's a tremendous document that I recommend to everybody. There's so much out of the UK that's just fabulous. But this is the Construction Industry Council Model Adjudication Procedure, which is available online, and it's a really, I think, a new experience for both of you. It's a useful tweak and tune to what the minimum standards are.
Fleur, I'll ask your perspective, closing thoughts on how contracts might need to change to deal with the adjudication.
Yeah, I mean, we had our standard for building contracts included adjudication provisions, but the main area of discussion wasn't actually on the standard provisions in the building contracts. It was more about the actual adjudicators and what nominating body you choose, or whether you're going to select or name any adjudicators. That was the kind of main area of discussion that we had entering into contracts.
Any questions in the room for our panel? I'll bring Andrea. I see Andrea in the back there. I'm going to bring our microphone around so that those on the webcast can have the benefit of the question.
So just more about that. Just a question, Duncan. You mentioned earlier in terms of what is subject to adjudication, the valuation of
Yes.
draws. And I think Chris mentioned sort of the role of the contract administrator, sort of touched on it. So if a general or were to challenge, a cutback, say for example, is it the owner that's sort of the other party in the adjudication, or is it the contract administrator, or who is it that are having a dispute over the valuation? And I guess, when you look at the way that the sort of structure works, you've got the owner and the consultant. The consultant tends to be engaged by the owner, and then you sort of end up in a 2-on-1 scenario. I'm just wondering, is that an issue that we're going to have to live with, or is it going to be 1v1, or any thoughts on that?
Yeah, well, I think that let's just pursue your example. Let's take a unit rate contract, and there's a dispute about units. So it will be an invoice from contractor to owner with a bill of units and quantities. It will be cut back because someone will say, no, there wasn't that much PVC pipe. We had quantities are there, and it isn't there. That will present itself as a dispute over payment of an invoice. So that will be a 2-party adjudication between the contractor and the owner. The consecutive provisions that I talked about could change that, though, right? Because there could be other parties brought in, and I add the bonding company, because the bonding companies are going to be, it's subtle, it's in Bill 142, and it's not being really, who's paying attention to that, but it would be possible for the owner to perhaps adjudicate that with a bonding company. But the short answer to your question is that would likely present as a 2-party dispute between the contractor and the owner over prompt payment of a unit rate invoice.
And then just one other quick one. These decisions by the adjudicators, will these be made available publicly, sort of in a system like Canley, for example? And if we're talking about having some adjudicators that maybe don't have a legal background, where do you sort of see the case law in this area going? I mean, we talk about CCDC; those are standard forms. So if you're going to start to have, interpretations of standard forms being made, do you see problems with that, or potential for inconsistencies, or any issues with that? And I guess the first question, obviously, will they be made available publicly? Can you rely on them in similar adjudicative proceedings?
So if this was a game show, Jay would hit the button. That would be called the $64,000 question. There'd be streamers and confetti. But that question goes to the heart of some discussion that's being had. We're fortunate in having Minister Knack. I've never met a more energetic, focused minister of a government, provincial government. He's very keen on transparency. He's very keen on your point. And there has been discussion, and I would put it no higher than that, of the antique paper-based system that we have now in the daily commercial news. How 19th century could we possibly be? And having a real-time, 24/7, 365 from your phone access to a provincial database that had everything about a project. So if you've got a Fluor gets a permit for a project. Once that permit's registered, every contract gets an access code. Everything goes in there. All the invoices, all the disputes, all the determinations go in that. So the privacy bubble would be over that dispute. The next, and I know we've got to wrap up, the next level of your question is, why wouldn't that be available to the public? There's a good argument for not doing that. The good argument is they're intra-binding disputes. So who cares if I say that GC7 doesn't apply in this case? Well, the short answer is no one, because on the next project is quick and dirty in the they're not binding. There's no lawyers stare decisis. So there's a good argument for maintaining privacy. It's a good question.
I know we do have to wrap up, but I want to give the audience just an opportunity to ask one more question if there's any out there. Okay, well, seeing none, let me thank our panel once again. Chris, Fluor, and Duncan, thank you so much for speaking to us today. Thank you to the audience, and have a great day.
Oh yeah, get the motor workers.
Upside down. Thank you so much. That was great. Appreciate you taking the time. Very well done. Yeah. Good. Thank you again. Good job. So